Hello and welcome. My name is Siobhan Willis. I am a member of the Camellia Rose chapter of Links Incorporated, and I'm here to talk to you this evening about estate planning. I am a practicing attorney. I have been practicing now for a little under 20 years. And over that time, I've spent a significant number of years practicing estate planning and helping people build estate plans. And so that's what I want to talk to you about this evening. Next slide. Thank you so much. Um, so estate planning. I've gotten so many different questions about estate planning. And so what I thought today we could do is talk a little bit about it. Hopefully I can give you some information that you don't already have. For some people, this may be just a refresher course. And for others, it could be new information. But what it is designed to do is to talk about um, what estate planning is, the documents that are needed as part of estate planning, and just kind of give you some general things to think about as you hopefully gather your documents to get an estate plan. The idea behind this is really to educate. We want to make sure that people have a basic understanding as to what they should be doing and how they can protect themselves and protect their families. So let's get into it. All right, so next slide, please. All right, so I'm an attorney, so of course I have a disclaimer. That's just the nature of who I am. So you should know that the information that is being provided this evening is general information. Everyone has a different situation. Every situation could be anything from simple to complex. And so you want to make sure that you speak to an attorney about your particular circumstances. Additionally, I am here in Georgia, and the information that I'm going to be speaking on is really going to be Georgia specific. So there could be people out there, obviously, in other states. And so that's going to be another reason why you want to make sure that you speak to an attorney about your particular circumstances in your state. And obviously, this does not create any type of attorney client relationship between us. Again, I'm providing very general information that is going to be applicable to most people, but not necessarily all. If you have specific questions, again, direct that to an attorney. Now, for general questions, please submit those. I'm going to give my presentation and kind of talk about these basic things within estate planning. But if you have some general questions about estate planning that come up as I'm speaking, please go ahead and post your questions, your comments, and then at the end, I'll try to address as many of those questions and comments as I can. Okay. All right, so next slide. All right, what is estate planning? Well, you think about your life, you think about all the things that we plan for in life. We plan for buying a home, we plan for having children, we plan for starting a business, we plan for retirement. Those are very significant points in life. And as you're planning and as your life is changing and you're embarking on new endeavors, you really want to have a plan together, an estate plan that's going to change and grow with you. So, what is an estate plan? An estate plan is planning in advance what you want to happen if you become incapacitated. If there's some unforeseen event or something that happens to you, what you want to happen. It's also a part of that, which most people understand, is that it is deciding who is to obtain your property upon your passing. Now, many of us don't want to think about those scenarios if something were to happen to us. And so, unfortunately, what that means is because we don't want to think about it, we don't plan. We don't plan for a situation where we could become incapacitated. We don't think about, well, who's going to make those decisions for me? And so, unfortunately, what it does is one, it puts you at risk because you don't have anyone speaking up on your behalf. And two, it makes it very, very difficult for your loved ones because they're assuming what you would want. And so we don't want to put our loved ones in that situation. So it's going to be really important to put a plan together as to what should happen to you if you can't make your own decisions. And then when you're no longer here, what you want to happen to your property. So let's go ahead and talk about estate, what an estate is, because there are a lot of misconceptions about what an estate is. Can we go to the next slide, please? Thank you. So what is an estate? An estate is essentially everything that you own. So, we're talking about homes, cars, 401k plans, IRAs, bank accounts, life insurance. That's one that people don't really realize is part of their estate, because we think, well, that those proceeds, I don't get them; they go to someone else. Someone, I'm leaving that money to someone else, but that actually is part of our estate, and so we have to think about that and account for that when we're thinking about how we want to structure our estate plan. Okay. Um, so estate planning is something that I think has a lot of misconceptions. People think that it's really for people who are just extremely wealthy, and that's not the case. I mean, when you start thinking about all the things you own, that list, it gets pretty big, and you really start to realize that you need to put a plan in place as to what is to happen for those things. And so that's why it's going to be really important to lay out your wishes ahead of time and do some advanced planning. Okay, if we can go to the next slide. So next thing I want to talk about are some basic documents that are part of an estate plan. So there are 4 documents that really typically come to mind when we're talking about an estate plan. That's a will, a trust, a durable power of attorney, or financial power of attorney. That's another name for it. And then an advanced healthcare directive. The advanced healthcare directive, that's what it's called here in Georgia, but some states would call it a medical power of attorney or medical directive. Those are all the same thing. Now, when we're thinking about those documents, the main 3 documents that really everyone should have are a will, a financial power of attorney, and then that advanced healthcare directive or that medical power of attorney. Those are the main 3. That trust is more of a optional document for some people. Again, everyone's situation is different. For some people, it's more of a necessity because of whatever their family situations may be. But when we're talking generally about most people, those 3 documents, a will, an advanced healthcare directive, and the financial power of attorney, those are going to be your main 3 documents that you really want to make sure that you have in place. Okay. What happens again when you think about people who don't do an estate plan, it really creates havoc for those that are left behind, because or even if the person is still with us and they're incapacitated, it just creates problems because people just don't know what to do. Everyone has opinions on what should be done, but they don't know what to do. Most people, when you think about family, we all have we can have our best intentions about our loved ones, but we all have our personal thoughts as to how things should go. And unfortunately, what happens is that when someone doesn't have an estate plan, family members start to say what they think the person would have wanted. And usually it's pulling from their own personal experience as opposed to our loved one who has passed on or who is incapacitated. We're not necessarily thinking about them. We're thinking about what we kind of want. And that's just human nature. That's what happens. So that's why it's going to be important to have an estate plan put together. There are, we can take examples from celebrities. There are a number of celebrities who have passed who didn't have an estate plan together, and it was very chaotic for their loved ones. Sonny Bono, Jimi Hendrix, Prince, Howard Hughes. He was an eccentric billionaire. Michael Jackson, actually, that's another one. Now, he was thought not to have an estate plan. It was later found by his loved ones, but they didn't think there was one at first, which is a whole nother point. If you're going to go through the work of creating a plan, make sure your family knows where it is and can get to it. Because at the end of the day, these are just documents on paper. And so if you can't find the paper, it essentially doesn't exist. So, for instance, if you are going to put your documents, if you spent time creating, which you should, you're going to put them in a security deposit box. Make sure your loved ones know that it's in a security deposit box. They know where that security deposit box is. They know where the key is and can access that key. If they can't find the key, then they can't get to the documents. So those are things that you want to think about. And Michael Jackson was a great example of that. They couldn't find the documents at first. But without an estate plan, it really does prolong the event of someone's passing, and it just makes it much more difficult. I brought up Howard Hughes as an example of someone who didn't have an estate plan. I believe it took his family, loved ones, I think it was 34 years in order for them to finish out and settle the estate. Now, obviously, that is an extreme example. He was a billionaire, and I'm sure we all wish we could be in that situation. And of course, the more money you have, the more complex it is, the longer that it can take. But even for very simple estates, it can take years, particularly if an estate plan is not in place. So again, very, very important. All right. So let's go on to the next slide. All right. So let's start with, I talked about those three basic documents, a will being one of the most basic documents that everyone should have in place. So what is a will? A will is a legal document which allows you to leave the property to the persons or charities of your choosing in the amounts of your choosing. It's where you appoint a personal representative, which is an executor, and that's what it's called in most states, who handles your final affairs. So this is someone who needs to be trustworthy, someone who's responsible. If they don't have to know exactly what to do, but they have to be resourceful enough to figure out who they may need help from. Oh, I may need to hire an attorney to help me, or I may need to hire an accountant to help with taxes. So they just need to while they don't have to know the ins and outs of how to administer an estate, they need to be resourceful enough to know how to find people to help. It's also going to be, a will is going to be very important. Many people don't know this, but at least here in Georgia, and I think this is the case for most people, most states. And let me just say, as I'm talking about Georgia, the things that I'm speaking of are very general. And so for the most part, they do apply in most states. And so it may look a little different. The documents may be called something a little different, but generally speaking, it does apply in most states. But again, that's where it's important to talk to a professional who can guide you in your particular state as to how things are done. But this general information, like I said, is pretty applicable within the United States. But in Georgia, and again in most states, a will is where you would nominate guardians for your minor children. So if you're a parent with minor children, it's going to be imperative that you have a will, because you want to say what happens to your children if you are not able to raise them, and you want to nominate someone. It's still a court proceeding. After that, the court steps in to appoint someone to be their guardian or their conservator. Guardian guards the body, conservator guards the money. So a court still has to step in to do that, but you have at least said to the court who you want, and nine times out of 10, the court's going to follow who you've nominated. Now, one question I typically get, and typically I do this presentation, there's the audience participation. So I don't have that. So I'm thinking of questions along the way that typically do come up. So I'll pause at points when I think of some questions I typically get. And one question that I typically get is, well, I'm married, and my spouse would be the person that would be the guardian of my children. So that really wouldn't be necessary for me. Right. I say, nope, that's not true. I mean, think about, how many places you travel with your spouse. What if something were to happen to both of you and now no one is there, and you've not taken the step of planning? And again, this is about planning for, situations where, one, we hope don't happen, and then it's also planning for situations we know will happen, right? We know part of life is death. I've had clients come to me and say, if I die, like, well, we know it's not if. Unfortunately, that's just a part of life. It's a matter of when. And so you want to be proactive. You don't want to assume too many things. You don't want to assume your spouse will be there to raise your children, because you don't know. It could be happening to both of you at the same time. So again, a will is going to be really important for parents with minor children to nominate that guardian and that conservator for them. A will only takes effect upon death. So before that, it's just a document that exists, doesn't have any power, but it's very powerful once that person passes on. One thing I'd like to talk about too, and bring to people's attention, is that a lot of assumptions are made as to how a will works and the power that it has. While again, it's very important, it does not control everything, all of your property. For instance, if you have property where there is a designated beneficiary, and you're going to see that in situations where there's bank accounts, life insurance, even 401k, there's a line that you fill out that you can say who you want to be the beneficiary of those funds. Anytime that you have that as an option, one, you should elect to do it because it's a much cleaner process and simpler process. And then two, that's like its own contract. And so whomever you have listed on those as beneficiaries for those accounts is superior to anything you have in a will. And so that's part of your estate planning, is to review those documents and those beneficiaries you've listed as well. Probably most people have heard of those situations where, the ex-spouse was named for the 401k as a beneficiary, and the person they got remarried and they never changed the beneficiary. And the new spouse is obviously assuming that they will receive those funds, and that's not going to necessarily be the case. And so imagine how heartbreaking that is. Obviously, if to have lost someone, and then money that you were assuming you would have as a resource is no longer there. So it's really important to review those documents and review those beneficiaries, and not just for your documents. Make sure you make your loved ones review it, because if you are left in a position where you're assuming that you will receive funds, but you weren't actually properly designated to receive those funds, now you are in a position of a very bad position that could have completely been avoided. So it's our personal responsibility to create our estate plan and make sure our wishes are laid out and are easy for our loved ones. But you want to make sure you remind your loved ones to do it for them, because it makes it easier for you too. So I always like to make sure that I talk about that, because that's one assumption that I think a lot of people make, or they don't take advantage of the option to write a beneficiary. One of the main reasons why you want to take advantage of anytime you can name a beneficiary for accounts to do so is because a will has to go through probate, whereas those accounts don't. And I'm going to talk about probate in just a minute, but with those accounts, essentially, you usually just have to provide a death certificate, and then you had access to those funds. And so that's why you do want to take advantage of being able to designate beneficiaries for those accounts, and you want to make sure your loved ones do that as well. It's a much easier, cleaner process. So probate. If you can move to the next slide, please. Okay. So probate. A will, like I said, has to go through probate. Actually, quite honestly, if there's a will or if there isn't a will, it has to go through probate. That's the mechanism for property to transfer from someone who's passed on to someone else. That's the process for it when it's in the will, or when there's no estate plan in place. So what is probate? Probate is a court proceeding where assets are collected, so property is collected. Heirs and beneficiaries have to be notified that the person has passed on. Debts have to be paid. That's an important one. A lot of times people think that when you die, that your debts are wiped away, and that's not the case. If there is money in your estate to pay your debts, then that debt has to be paid. Question I get here a lot is, as a surviving spouse, do I have to pay my spouse's debts? Not necessarily. It depends. Now, if you've co-signed on whatever that property is, if you signed your name to it, it's a credit card that you primarily have used, and they can prove that, then yes, you can be responsible for it. But many times you're not responsible. Just because you're married doesn't mean that you're necessarily responsible for it. Now, that's going to vary a little bit, sometimes in states, but for the most part, the spouse is not automatic. So again, that's one of those situations where if you have questions about it, you want to talk to an attorney. I have a lot of people that I've seen over the years who just automatically pay it. The parents have passed on, and the children automatically pay the debts out of their own pocket. The spouse automatically pays the debts out of their own funds, and that's not something that you automatically necessarily have to do. That's why you want to talk to an attorney before you do that, to figure out what your responsibilities are. But again, going back to what probate is, debts do have to be paid out of the state funds, and once those debts are paid, then any assets that are remaining can then be distributed, hopefully according to a will, because you have one in place. If not, then we'll talk about it a little later as to what happens. But hopefully there's a will in place, and then those assets can be distributed, and then the probate case can be closed. And it varies how long it can take. It can take a matter of months. I mean, I've seen definitely with COVID that number has increased to what normally would take 6 months is now potentially taking a year or longer because courts were backed up. But it could take a matter of 6 months to 34 years so or longer. So it really varies how long that process can take. Obviously, the more complex the estate, the less planning that was done, the longer that it can take. Okay, next slide. Okay, let's talk about trust. This is one of that document that I said that is more, I would place it as more optional again for some. But it's a good time to talk about it now because it does in some ways work similarly to a will, but very different at the same time. So what is a trust? A trust is a legal entity that can hold property, and it's based off of a written agreement between the person creating the trust and the person administering the trust on that person's behalf. So a trustee. So you have a grantor who's giving the property to the trust, and then you have the trustee who's over the property in the trust. A lot of times people have a hard time really kind of conceptualizing it because it's not something you could touch and feel. It's not tangible as far as what you would think of for something that has to own property. It's tangible in the sense that it's a document, but not, it's hard to think a document can own property, and it can. The example I typically give is think about a business. For the most part, for a lot of businesses, particularly, when you have entrepreneurs or startups, most businesses only exist on paper. They don't necessarily have a brick and mortar store, but that business can still own property, can sell property, and purchase property. And similarly, a trust can do many of those things as well. And so think of it like that. Once a trust has been properly created, it can hold property. It has to be what's called funded. And so, when I say that it's been set up properly, you want to make sure certain things are done. But assuming those things are done, it's its own entity. And so a trust can take effect during life, and it can take effect after death as well. So the trust can say what you want to happen to property while you're living. Let's say you don't want to manage your property more. You're getting older and you want someone else to manage it for you. You can say that and put parameters in place in the trust to account for that. And then also it's a lot of times utilized after death to account for who's to receive property upon someone's passing. If we can go to the next slide. Thank you. So there are many types of trust, and there are many reasons to get a trust. One of the biggest reasons for most people is that it can help avoid that probate process if funded, meaning that so the way that a trust works is that it can only control property that it has been given the legal authority to do so. And that means for like a house being deeded over, like a deed that you signed when you bought your home, the same type of mechanism has to happen in order for a trust to own it. It has to be deeded over to that trust. So that's what I mean when I say if funded. So property has to be put into the trust in order for it to control. But once it has been put into the trust, then there's technically nothing in the estate to then probate. And so then trust does not have to operate through that probate process, and it can be administered very soon after the person has passed without having that court proceeding in place. So that's one of the main reasons a lot of people will get a trust, because I know up until very recently, last 10, 15 years or so, people always assumed trusts were for just wealthy people, but that's not the case. And the avoidance of probate, again, when done properly, a trust being able to avoid probate is one of the reasons why people do it. Another reason, and why a trust is very beneficial, it's when you're talking about leaving property to minors. you don't want to leave property directly to a minor. I don't know about you, but when I was 18, if I received $1 million, what would have happened to it by the time I was 20, right? We're not in a place when we're young to make certain decisions about money. That hopefully comes when we're a little bit more established, that we know how to treat money and how to respect money, right? And so you don't want to leave it, and 18 is an adult, so technically they can have it. But when you're talking about minors, you definitely don't want to leave that property directly to them. And in most states, they can't have it. So there are mechanisms that are put in place as to how that money has to be managed. But why not make that decision yourself? So the idea with that is property is put into a trust. Someone is appointed as a trustee. If it's the case of someone you're pointing to handle it for your minor children, it would be obviously someone who you trust, someone who kind of understands how you want to raise your children, or things you would want them to have as it relates to monetarily. And then that while that property belongs to the children, they don't have access to it. It's controlled by the trustee, which is why that trustee position is a very trusted position, right? Because that person has the control, even though they don't technically own it. So question I get here is, what if the trustee took all the money from the kids? That would be very bad. It's not a matter of whether or not if they can do it. It's a matter of what would happen if they did, right? So it's illegal, right? So people do illegal things all the time. So you can't say it would never happen. But if they're ever caught, they go to jail. Because again, that property belongs to those minor children. It does not belong to the trustee. They have to do things for the benefit of the children and in accordance with the wishes that have been laid out in the trust. But that's another good reason for a trust. Trust is also really good for people maybe who don't manage money well. So if there's a loved one who you have that doesn't manage money well, or I've seen it in situations where someone has maybe a substance abuse issue, you want to leave them something, but you don't want them to have that control over the money to protect themselves. And so then that's a situation where you would appoint that trustee and have that property in the trust. A trust is very flexible, much more so than a will. With a will, you leave someone the property. Once it's gone through that probate process, it's their property. They can do whatever they want to do with it. Whereas with the trust, you can set some controls, you can set some parameters on how that money is to be treated. And so that's, again, that parameters, those controls are why it's good for minors, and why it may be good in whatever your particular situation may be, since you can still exercise that control. I've seen it where grandparents are leaving grandchildren money, and they put parameters. Well, they want them to they can't have the money until they're 25, and they would have had to have graduated college. They set parameters like that. I've seen people set parameters where they don't want their children to receive the property unless they do X, Y, Z. They don't want them, unless, if they've had drug problems, they don't want them to be able to get property in the trust unless they submit to drug tests and come back clean. So people have done a variety of different things with trusts, and they're very flexible up into what the law allows. I mean, there's a lot of things that can be done within the trust, and so that's why a lot of people like them. They're also good for estate tax reduction, if that's a situation. If you're a high net worth individual, we're talking millions upon millions of dollars, then it can be utilized. Trust can be utilized for that. They're good for long-term care planning. They're also good for people if you have a loved one who is disabled, and you don't want to affect their benefits, their government benefits. A trust is a good mechanism for that. It's also very good for charitable donations if you want to leave money to the charities, the churches or organizations of your choosing, like the Links Incorporated. Of course, I have to do a little plug there, but but no, you can leave property to whomever you like. But if you are leaving it to a church or organization, a trust is a good place to do that, because again, parameters can be set on what you want the money to go to, what kind of programming and things like that. So it's really good for that. Next slide, please. Okay. So the next document we're going to talk about is a financial power of attorney. Again, this is going back to those main three. One other thing that I want to talk about when we're talking about trust in the will, a lot of times I get the question of, well, if I do a trust, then I don't have to do a will, right? And I say no to that, definitely, because they're in some ways designed. While there's overlap, they are designed to do different things. So what has happened a lot, what happens with people, they spend the time, they develop a trust, they spend the money, they spend the time, the energy, and do the planning and create a trust. They properly fund it, meaning they put the property into the trust, and then they go about living. They go about buying other property, they go about living their life, and they forget to put the other property into the trust. And so, again, like I said earlier, a trust can only control what it legally has the right to control, and what it legally owns. And so, if that property was never put into the trust, it can't control it. And so, then what happens with that property? Then it's treated as if there, if you don't have a will, it's treated as if there's no will, and you don't want to be in that situation. And so that's why it's always good to have a will, because if nothing else, it can be a safety net. Again, when you're talking, there's other reasons to have it, right? We talked about minors, nominating guardian for minors and things of that nature. So there's other reasons to have it. But let's say that's not your situation. Let's say you don't have children, or your children are adults. Again, that will is a good safety net for trust, because it protects those assets that typically most people, it's very common, forget to put into a trust. And the will can be very simple. It could be something to the effect of any property that I have in my passing gets to go into the trust. So it could be very simple, but it's something that's needed. So I definitely think even if you have a trust, you should still have a will. Okay, so now we're moving on to financial power of attorney, durable power of attorney. Again, it could be something different depending on the state. But essentially what this type of document is it says who can make medical decisions for me if I am unable to do so. So if someone's in an incapacitated state, they can't, I'm sorry, medical. I said medical. It's financial decisions. I apologize. Who can make financial decisions for me if I'm unable to do so? So it's a document in which another person is named to act on your behalf for financial matters. It allows someone to act as your agent. And what happens with that is that anything they do on your behalf while they are your agent, you are then responsible for. So if they, if you give them the power to buy property, if they buy and get into a mortgage, and when you're incapacitated, then you would be responsible for that if they were acting on your behalf. So financial power of attorney is a very, very important document to have. Both this and the medical power of attorney, the Advanced Healthcare Directive, again, same document, just different terms. Those documents are going to be really important. These are documents that you hope you never need. You hope you're never in that situation, but it is imperative to have them if you are. And that's where, again, that planning comes into place. Because you don't want your loved ones to be in a situation where no one can access your money, no one can pay bills, rights. Even if you're incapacitated, bills still have to be paid. And no one can do that on your behalf, but for going to a court and requesting it, which is one, expensive, and two, time consuming. So you don't want to put them in that situation. So that's why it's going to be very important to have a financial power of attorney in place. And again, it controls who can make financial decisions for you if you're unable to do so. Next slide, please. An advanced healthcare directive, or medical power of attorney, or medical directive, same thing. This document controls who can make medical decisions for you if you're unable to do so. It also, in this document, says who can, it states your end of life wishes, situation where doctors say there's nothing else that can be done, what you want to happen. You want your life extended as long as possible, or you want your natural death to occur. Depending on people's circumstances and what they've been exposed to in their life, people have very, very strong feelings about this. And so this is a very personal decision. And so you want to exercise that right to make personal decisions about your care in that type of situation, what you want to happen. And so that's what it's designed to do. Now, again, in Georgia, that is done in one document, the Advanced Healthcare Directive. In many states, that could be two documents. That could be a medical power of attorney and a medical directive. Those could be they could be two different documents, and it could be called something different. But like I said, here in Georgia, that's all combined into one. The who makes medical decisions for you, and then what your end of life preferences are. Again, one document. Um, and then it's really important to keep in mind that it only becomes effective if you are unable to make decisions for yourself. If you can communicate, and communication can be blinking, communication could be writing. You don't have to necessarily be able to speak, but if you can communicate, doctors much more prefer to talk to you. And so that's who they're going to talk about treatment options and treatment plans. It's really designed to be, if you cannot communicate, you are incapacitated, someone is there to make those decisions on your behalf. Now, both the financial power of attorney and then the advanced healthcare directive are only effective while you're still living. So people have asked, the person's passed, and I take their financial power of attorney to go to the bank to pull out funds in order to pay for the funeral. That's not what it's designed to do. Once a person passed, that document should not be used, and you can get into a lot of trouble if you try to. So it's really just designed for when the person is alive and cannot handle their affairs on their own. That's what it's designed to do. Let me see. I'm trying to think if there's anything else I want to make sure that I discuss about those documents. Those are the main two things. But now let's kind of talk about why it's important to do some estate planning. Next slide, please. Okay. So why do you want to plan? Because if you don't, someone who you don't know, who you've never met, will make decisions about you for you. And who wants to be in that situation? Who wants someone else to make those decisions about themselves? They could be making decisions about what's best for you when you're still here. They don't even know you. They don't know what your wishes are. They don't know who you know. They don't know who you would not want making decisions for you, and who you would. So why not exercise your right to do that and do some planning ahead? Because either you're going to do it or someone else is going to do it for you. Okay. Another reason to do estate planning and why it's important is because people who you may not want to make your decisions can make decisions on your behalf. Example of that, the person who you pick to handle your financial matters may not be the person who you want to handle medical matters. Maybe you have someone in your family or a loved one or a friend who is very good about making monetary decisions. They are very responsible. They are, cut to the chase as to what needs to be done. They have a to-do list and they get it done. That is a good person, and someone who's trustworthy. That is a good person to be your financial power of attorney agent. But that same person may not do well in medical situations. They may not have patience to kind of see. You may say you want your life extended. You want the doctors to give you a little bit of chance. They may be that person that says, no, you said that they're in a compromised state. Let's just go ahead and pull the plug. They may not be that person who's good in those type of situations, or they may not just be able to perform in those type of situations. They just, when you're talking about that medical and that human element, that's very different than money. And so, you may not want that, but a judge would not know that, but for you saying that and choosing that and exercising that right to make your decisions as to who should make those decisions for you. They may pick the closest person to you. So they believe, because they think, they could pick your spouse because that's your spouse, and they think they'll make good decisions for you. But that may not have been who you would have selected to make those decisions. So again, you want to exercise your right. And that's why you want to plan. Let's say you pass on and you don't have any kind of documents in place. You don't have a will, you don't have a trust in place. Well, the legislature has one for you, a very generic one for you. So again, if you don't decide who you want to get things, then government and a court decides who you want, who gets your things. And a lot of people make assumptions as to about who that is. A lot of people assume who would get their property. And it's a lot of times different. People are usually very surprised to know the process and how the legislature has decided who gets what. And so again, you don't want to rely on that. So again, if you don't do it, someone else will. So you should go ahead and do it. Again, assets can end up with people who you just would not think of. Again, if you're not checking your documents, you're not looking at those beneficiaries, the ex-spouse who you don't get along with is receiving your property upon your demise. So again, you want to make sure that you go through the process of planning and executing those documents. Next slide, please. Another reason why it's good to have an estate plan in place is because there could be, depending on your situation and the amount of money you have, you could be missing out on opportunities to protect your assets and to avoid certain taxes that necessarily, by pulling certain things out of your estate in order to get your estate value down, so it's not, because it's a significant tax when you reach a certain amount. And so, you could be missing out on opportunities to protect some of those assets. Again, we talked about that will and how you nominate a guardian for your minor children. If you don't do that, a judge is deciding. A judge who does not know you, does not know your lifestyle, does not know how you've raised your children, your wishes for your children, does not know your children, would decide who would be their guardian, who would be their conservator, who would manage your money, who would manage your body. And you don't want to put your loved ones, your children, in that place. We have a responsibility to our children, to our minor children, right? And that does not go away just because we're no longer here. And so you want to plan for that, okay? We talked about leading to family disputes. It happens all the time. I used to have a phrase that I used to talk to families about. I also handled probate matters, and I would talk to families about it all the time. I call it the no problem family. It's always those people that come and say, we've never had a problem in our family before. We always got along, and now everything has hit the fan and everyone is upset and everyone is arguing. And it's really, really unfortunate because, unfortunately, a lot of times with death or with very difficult situations where maybe someone is incapacitated, sometimes it does bring out the worst in people. Sometimes it doesn't necessarily even bring out the worst in people, but it brings up old emotion and stuff that people have buried. So many things that you let go. You just didn't deal with, but somehow tragedy has a way of bringing those things out. And now when a family should be coming together, should be working together, should be grieving, should be coming in closer, they're being torn apart because that person did not exercise their right and their responsibility. It's more than the right, it's a responsibility to have an estate plan put into place. And again, I'm saying these things as far as what you should do and what you should make sure your loved ones do, because you don't want to be that family member who's left with a mess to deal with, who's left arguing with people when that just could have been avoided, right? So again, make sure your loved ones have their estate plan in place. Those no problem families saw it all the time, and it's really, really unfortunate. So make sure you have documents in place. Another reason why it's really important to have an estate plan is because it can help create generational wealth. And that's extremely important in certain communities. In our Black community, that is something that we typically don't do. Unfortunately, it's not something that you see as prevalent. And so, you've worked very hard, and this is true in all communities, right? You've worked very hard to acquire assets in your life, and it may not be much, right? But it's yours. Why not pass it along to that next generation so you can set them up to be in a better position than where you were at their age? Why not give them that? Why not pass it along, right? And again, you really unfortunately see it a lot of times in the Black community. We don't do that. That is our right. It's our responsibility. We should exercise that. It's unfortunate that that's not done. And then what you'll see sometimes is, depending on the situation, that property can end up with the government if no one steps up and no one even goes through the process of probate. Let's say there's no will, but no one goes through that process. After time, that property potentially could end up with the government. And why should you work so hard for that to happen? You don't want that. Why not Leave it with your loved ones. Leave it in your community. Leave it with your church. Leave it with your charity. Leave it with someone. Decide who you want to have it and give it to them. Again, it's really important for that generational wealth. Let's step up to that responsibility of helping the next. That's a way of pulling up that next generation, that we can do, right? Sometimes we can't do much in life. And unfortunately, sometimes we can do a little bit more in death. Do that for them. Exercise that responsibility. Let's see, next slide. I think that might be it. Okay. All right. So now questions. Again, I was saying if you had questions as I was presenting, to please go ahead and post it. I'm going to look to see if I see any questions that come in. Let's see. Okay. So I don't see. Oh, well, let me see. Must or should family be informed of updates or changes to wills and trust? They should be. So I get the question. So let me take a step back. So sometimes the question is, should I give my documents to my loved ones? And it really just depends. You don't one thing, so you have to weigh it because, in one hand, you do want people to have your documents to kind of have them. It makes it a lot more accessible. The originals are the most important document. You should keep your originals and maybe give them a copy and let them know where the originals are. The originals are the most important documents. But maybe you want to give them a copy of it. Maybe you don't. Reasons to give it is that they at least know the documents is there. While the originals are best, there is something that can be done with the copies. At least it's something that the court could go off of if it's a will. If it's a trust, right? Again, there's at least a document in place that there's kind of a roadmap at least for people to follow. But also people have said, you know what, I don't want to create any mess. At least they'll let, while I have laid out what I want, I don't want to deal with it. Let them deal with it when I'm gone. So I've heard people say they don't want them to have it. So it really just depends. So that's the first part of that. As far as whether or not you should give them updates would depend on how you answer that first question. You don't want too many documents floating around out there. So let's say you've let them see, you've given them a copy of your will, or you're giving them a copy of the trust. If you make updates to it, get back the document that you gave them and then give them either the replacement. Now, if it's just an update, then make sure they attach it to what they already have. But if it's completely replacing it, you want to take back what you gave them, because you don't want to be in a situation where people are fighting because you have two documents in place. Even if one is dated later, it can cause a lot of problems. So I hope that answers your question, but in some ways it kind of depends on your comfort level with giving your documents to your loved one. I'm going to see if I have any other questions here. I have a question. Is it true that is it true that if a debt was incurred during the marriage, the spouse is responsible after the death of the other spouse? I touched upon this a little bit earlier. That's not necessarily true. It does. There are certain factors are dependent on that. One, it depends on where you live. And then two, it depends on how that debt was incurred. Was it something that both spouses signed as being responsible for that debt? If that's the case, then yes, you're responsible for it. Is it something that just the spouse, that just your spouse incurred? If that's the case, then you are not responsible for it, but the estate may be. And sometimes people have a hard time understanding that distinction. Your spouse owns a certain amount of property. They own certain things. They have bank accounts. They have their own bank account. They have their own 401k. They have their own 401k. Actually, I should not use that as an example because that passes outside of probate. That's one of those things, again, has its own contract. So that's not part of probate. And so that's another reason why I name a beneficiary, because those things don't go in that probate process. Those things aren't counted when you talk about paying off debts. You name a beneficiary, that's their money. But let's talk about that bank account that maybe you didn't name a beneficiary for. Let's talk about property. If your spouse had that, then whatever they had is what's used to pay off that debt. If you had no involvement in that debt, then your funds should not necessarily be used to pay it off. But again, everyone's situation is a little different, so you do want to talk to an attorney about that. But definitely don't go on automatic thinking that just because the debt was incurred during the marriage, that only your spouse incurred, that then you are responsible for it after they pass, and that's not always the case. Let me see if there's any other questions. Let's see. I think that might be all of the questions. Let me just make sure. Oh, I have another question here. Should passwords to financial accounts be included in the will? I would not include that in the will. One thing to keep in mind is that a will does, again, go through probate, and probate is a court proceeding, and most court proceedings are public. And so whatever that information is becomes public information, right? And you want to protect those passwords even after death, right? Because there are people who would utilize that and can create havoc, even for your loved ones who are trying to deal with things that they've identity theft and things of that nature. You don't want your loved ones to have to deal with your identity theft when you're no longer here. So I would not advise that those passwords be put into the will. What I would advise is that instead you create a document that maybe you just put with your important papers. So you have you've done your estate plan, you have your will, advanced healthcare directive, financial power of attorney. Those documents, you have those together. Your loved ones know where to find and can access those documents. Then go ahead and slide those, create a list of all your passwords, all your accounts, and and while you're doing it, create a list of all of your bank accounts. Create a list of all of your where any place that they can find money, and then go ahead and put the passwords down there. They don't have to get it now, so you don't, so people have said, well, then they'll have access to everything. Well, no, you don't have to give them access now, as long as they can get it when you're no longer here. And then that way they have a document to go off of and they can get into those accounts. And it's really good to put down the accounts that you have, because a lot of times people don't know. They don't know what bank account you have. You used to be at Fifth Third, then you moved to Chase, and then you moved to USAA. They don't know. And so a lot of times, there could be that money out there. Again, that's part of our responsibility, creating that generational wealth, is that we give our loved ones that information, right? And so you want them to know what accounts you have, so they know where to start. That information is not just contained somewhere. If it can't be found, private investigators are hired. If there's money for it, I mean, it's a process, and sometimes they're never found. So go ahead and make it easier for your loved ones and lay out the accounts that you have, and then yes, go ahead and put those passwords there, but I would not include that as part of your actual will. Let's see, anything else? Okay, all right, I think I've answered all of the questions that came in. Let me think. I typically I was trying to make sure I answered questions that I typically get. Just one other thing that I kind of touched upon, but I usually get a question about, is estate taxes and how that works. So the way that works is going to be different in every state. I know that's been something I've been saying a lot, but that is the case. So every state does things differently. For instance, in Georgia, we do not have a state tax, right? So Georgia does not have an estate tax. We follow the federal guidelines. And so now what is true for most states and even federal is that there is an exemption amount, meaning that if someone owns, when you look at all of their assets, all of their estate, life insurance, house, cars, all the stuff we talked about, bank accounts, all of that, and it's valued at a certain amount or less, then there is no tax. So for instance, in Georgia, we follow the federal estate tax exemption amount. That is, this year, I think that's about $12 million. So while it would be wonderful to have more than $12 million, it's like 12.6, I think it is. So while it'd be wonderful to have more than that, there are significant taxes that come along with that. If you have if all of your estate is valued at less than an amount, then it's exempt in Georgia. Then it's exempt from being taxed. If it's above that, it is significantly taxed, and that's when you want to utilize some of these vehicles to help maybe reduce those tax burdens. But that's a question I get a lot, is the estate tax. The other question I get a lot is inheritance tax. So estate tax talks about what is valued in an estate and whether the estate has to pay the tax. Inheritance tax talks about whether or not the person who has inherited the property has to pay a tax, and that's going to be different in different states. So so you want to check with your state to figure out if there is an inheritance tax. In many states, the answer is no, but in some it is. So you want to check with that. But those are two questions that I typically get that I want to make sure I addressed. All right, so that's all that we have time for. We are reaching the end of our hour. I hope I was able to provide some information that you did not know. If you already have an estate plan together, great, good for you. Go check it, make sure it's still accurate. You should be looking at these documents about every 5 years or so to make sure they're still accurate. Life happens and we forget, and things change, relationships change. So look at them about every 5 years. If you don't have it, but I hope that you found some information out of what I said that's helpful. But if you don't have an estate plan, now is the time to get one. Hire an attorney to help you with that. It's really important for you and for your loved ones. So thank you for joining me this evening. I wish you all the best, and go get those documents either changed and updated or created. Thanks so much. Take care. Bye-bye.